Hello, welcome to the first outline of 2024. So happy New Year to everyone. I hope you all had a relaxing festive season, albeit I'm not sure, Ian, quite how late in the year you can say Happy New Year, but it is our first one, so I'm going to do it now. But welcome to you all. Today we're talking about the levelling up and regeneration, which you will remember possibly we were going to talk about in December until biodiversity net gain came in with an element of urgency. So we talked about that instead. So we are now finally talking about the Levelling Up and Regeneration Act, an act that had quite a complicated process through Parliament. I think from memory it got through 3 Secretaries of State. Might even have been 4, but I think the 4th was the same as the first, because Michael Gove started it, and then by the time we finished it was back again. And during that time it changed quite a lot. It was going to include zoning then disappeared. So today what we're going to try and do is just look at some of the changes that did make it into the final cut, and just think about what they're going to mean moving forward. I'm joined today by Ian Graves, a legal director in the planning team and a regular contributor to Outline. I think it's probably worth saying, Ian, isn't it, in the introduction, there's a lot in the Act. We're not going to cover it all today. We're going to try and talk about the more interesting stuff. It's also fair to say that very little of it is actually in force yet. There's a lot of detail yet to come in regulations, so we're going to keep out of the detail today as well. And I suppose the other thing just to note is there's a question mark over quite a bit of it as to whether it ever comes in, depending on the outcome of the general election. Because there are certain parts that the Labour Party have already indicated they don't like. So with all of that in mind, we will try and cover the interesting stuff that we think people ought to be thinking about a little bit at this stage. The one thing we're not going to talk about in any detail is environmental outcome reports, which is the replacement or the proposed replacement for environmental impact assessment. There's a lot in that, and that's probably a session in its own right. So we will cover that as a dedicated session as and when we get more of the detail in regulations.
I mean, some of these topics, to be honest, are as you say, outlines in their own right, aren't they? So there is a lot for us to cover, I think. And I think some of the points we'll mention, but we could probably talk for longer about them.
Yeah, absolutely. As ever, please do ask questions. If you put them in the Q&A function, we'll try and answer as many of them as we can as we go along. But I think sort of just to kick off with, I have to start, because it's some regular viewers will know, but it's Section 38.6 is like a sort of religious mantra to me, and it's changing. And I'm going to have to learn a new Section 38.6 or a new section entirely. So I think one of the biggest changes, it seems to me, and it is quite a significant one, is the proposal to change the current statutory test, which I'm sure everybody knows. At present, Section 38.6 of the 2004 Act says that if regard is to be had to the development plan for the purposes of a determination under the Planning Act, the determination will be made in accordance with the plan unless material considerations otherwise. That's been the statutory test since long before the 2004 Act. It was the same test, albeit in a different section in the 1990 Act. But there are some fundamental changes to it. And sort of just before we get to what the change is to the section, I think the sort of first step in the change is the new concept of the National Development Management Policies, isn't it, Ian?
It is. And I mean, I think, this is sort of symptomatic of what I think is one of the sort of themes of the changes in the Act, which is a bit of a tension really between sort of localism and more sort of central control, or at least influence on planning. So national development management policies will have a statutory footing, and they have the same status, in fact, a bit more, a bit higher status than the development plan. Because when it comes to doing the planning balance, as you say, it'll be the local plan and the national development management policies that will be considered together. And in fact, in the case of conflict, the national development management policy will take precedence. So, of course, what that means is that policy set at government level will now have that statutory status. So, whereas at the moment we have the NPPF, which is a material consideration, actually, sort of potentially NPPF style policies will have that weight, the same as the development plan under the new section.
And I think just sort of thinking about what are the national development management policies, and the government sort of indicated we shouldn't, a while ago now, I think it indicated indicated in response to a question in Parliament, but we shouldn't assume it's the NPPF. And I suspect there are bits of the NPPF that don't quite work, but it seems to me what the document's likely to include is things like, for example, the Greenbelt section, the heritage section, those bits that are more about determining planning applications, and those bits where, frankly, local plans at the moment tend to just take the policy framework wording and incorporate it into the plan. So we potentially are thinking, don't we end up with two documents at national level, one being something akin to the NPPF or a sort of more strategically focused document, and then that sort of more nitty-gritty processing applications, determining applications that will be the national development management policies. And I think that the sort of the change in terms of the statute is there's an amendment to the existing section 70, subsection 2 of the 1990 Act, which is the section that says at the moment that if you're determining a planning application, you have to have regard to the development plan. That's being amended to say, if you're determining a planning application, you have to have regard to the development plan and the national development management policies, whatever they end up being. And that then filters through to section 38.6 or to the replacement of section 38.6, where, as you say, it's going to be, firstly, you have to have regard to both the development plan and the national development management policies. Secondly, I think for me, if there is a conflict between the development plan and the national development management policies, then it's the latter that takes precedence. That's there clearly in the statute. So it overrides the local plan to the extent that the plan is in conflict. So you've got a difference at the front end of the test in that it's no longer about conformity with the development plan, it's about conformity with those two documents. And then the back end of the test, material considerations are still there. Material considerations can still outweigh a conflict with those statutory documents. But those material considerations have to strongly outweigh the conflict with those documents. And I think that there's quite a lot of change in that. But for me, I think, but firstly, as you say, Ian, there's that sort of loss of localism. And we may or may not be at the end of a Conservative government, but it's interesting that if this is the end, then one of their final acts is to kill off, it seems to me, to quite a large extent, whatever was left of the localism agenda that they entered government with in 2010, because this is now about, for the first time under our plan-led system, this is about national government, certainly in England, and of course these changes do only apply in England, but national government actually setting a large chunk of what traditionally would have been local authority territory in the development plan. But the other big change is this strongly. I wonder, for me, I'm not sure quite whether that's a substantial change or not. I don't know what you think, Ian.
It's difficult to say, isn't it? I mean, I think, in terms of the mindset of a decision maker, I mean, I suppose it might sort of subtly change how the decision maker approaches that planning balance. And that obviously is the intention, isn't it? It's supposed to give the local plan and the national development management policies a sort of a higher status versus material considerations. But that said, I mean, I suppose if you think about it in terms of legal decision making, I mean, once the decision maker has performed a balance and concluded that material considerations outweigh the plan and the development management policies, I mean, is there much difference between outweighs and strongly, strongly indicates strongly outweighs? I'm not sure really that there is in a legal sense. Courts have been very keen, haven't they, to sort of protect the discretion of decision makers in these sort of situations. So when carrying out the planning balance, and I'm not sure there are many situations actually where a court would say, in the situation of just the test being material considerations indicate otherwise, that's a rational judgment. Whereas where the test is strongly indicate, actually, it becomes irrational. I'm not sure there are that many cases where that might apply. And we were chatting beforehand, weren't we, and trying to sort of generate some hypothetical examples of where that might, where that might be the case. And I don't know. Perhaps if you had a sort of, an inspector's decision that was, sort of framed in a way that it was obvious that it was a very finely balanced decision. Perhaps you might be able to make an argument that there was some sort of irrationality there. But I'm not sure actually that it makes as much difference as is probably intended.
I agree with that, and certainly I agree. I think it's highly unlikely we're going to see a lot of challenges based on it, because it is real planning judgment stuff, and unless it's completely bonkers decision, the courts are just going to leave it to decision makers. But I think it's kind of, if you've got an inspector, and I'm assuming inspector, because that's probably unfair, but usually you argue about conflicts with a plan on appeal rather than a planning application, but it applies in either scenario, of course. But it seems to me, if you've got an inspector who wants to approve the scheme in the face of a conflict with the plan or with the national development management policies, all the inspector's got to do is to sort of apply his mind properly, but conclude that these material considerations do strongly outweigh. And at that point, unless you've messed up your analysis, you're sort of JR proof or statutory challenge proof.
And
But
I kind of think that's how sort of, that is actually how inspectors think, really, because I think generally, the development plan is afforded quite a lot of respect and weight in the process, isn't it? I actually think your material considerations have to be quite strong.
And that was a point I was just about to make, is I think where it might apply, or it might have relevance, is where actually the material considerations probably do outweigh, but the inspector or the planning authority isn't sort of still minded to approve. Then they've sort of got a bit of a get out where they're able to say, well, actually, yes, they do outweigh, but to my mind, it's not sufficiently strongly outweighing to justify an approval, therefore I'm going to refuse. So I think that there will be differences, but it's going to be just differences at that first instance that aren't really sort of the subject themselves of statutory challenges or judicial reviews in due course, I think.
Yeah, just going back to the national development management policies, I mean, I think that, there's no doubt that that's the more significant change. And I think, I always think one of the things with legislation is unintended consequences. So, we tend to sort of, when we're sort of modeling, what we think the impact of these things will be, we always assume that it will be similar to the current system. I mean, but actually, as soon as central government has that sort of level of, those sort of levers that it can pull in terms of planning, it would be interesting to see which direction this goes in. It could be in 10 years' time, actually, planning is done much more on a national level. And we were talking beforehand, weren't we, about the sort of, if you look at things like services in the NHS, for example, while people like to say that they want control and so on to be devolved down to clinicians at on the front line, actually people don't like postcode lotteries. So what ends up happening is a lot of the control gets pulled back to the centre. So I think it will be quite interesting to sort of to see how that develops. Really, I think that is quite it's a big change, as big a change as I've seen, I think, in that sort of arena since I've been involved in planning, really.
I agree. It's a sort of a philosophical shift.
Yeah, previously it's all been the other way, hasn't it, towards localism, whereas actually I think this is quite a substantial sort of pulling back from that.
And that probably moves us on to the second topic that I think is worth just covering very briefly, which is the changes to local plans themselves, which are in part influenced by the national development management policies. And the link for me is that new local plans coming forward will not be able to contradict national development management policies, NDMPs, I suppose we're going to start calling it, but also they shouldn't replicate. So actually, I think one of the benefits of this potentially is a more sort of efficient, slimmed down local plan. It has frustrated me for a long time that there are huge duplications between national and local plans, because there's a obsession with including it all in the local plan.
Yeah. You get those bits, don't you, where it's sort of a whole policy that just replicates the green belt policy in the MPPF,
so
or heritage, or whatever it is.
Unnecessary verbiage to think about. But of course it needed to happen in order to keep it the state as a development plan.
Yes, yeah.
Now it won't need to do that. So in theory, local plans should become shorter and more focused on the sort of practicalities of delivery and site allocations and those sorts of things. But I think we probably agree the whole local plan making process is not the most interesting, so I'm not sure we need to spend a lot of time on it, but I think it's worth flagging up for me just a few points. There are lots of changes, but the ones that stuck out for me and were the sort of the 30 months maximum time for bringing forward a plan. We've seen so many attempts by national government to sort of speed up the plan making process. This is the latest. For me, what's the consequence? Well, the consequence seems to be in the legislation that the Secretary of State can then effectively take over the plan process and direct that a plan be put in place. I query whether that's actually that broadly, other than the 30-month timescale, those powers already exist, and the Secretary of State is always very reluctant to use them because it's a massive administrative task for him or her.
Well, that's why the local authorities don't do it in a quickly, isn't it? So why the Secretary of State would want to make it his or her problem, I'm not sure. But yeah, I agree. I mean, I think there would have to be a real will, wouldn't there, in central government to ensure that plans are that plans are made. And I mean, it's possible that actually they'll become relatively less important, as I say. If we've got national development management policies that have that status, it's possible that they'll be relatively less important anyway. So perhaps the Secretary of State would be less inclined to intervene. And particularly with the sort of some of the changes around the obligations on councils in terms of the number of houses that they have to plan for and those sort of things. But actually whether the Secretary of State is sort of still interested in enforcing this sort of timescale, I don't know. Obviously, it would have been very important if the zoning elements had stayed in the bill. So, I mean, I actually think that some of the things that are made into the Act are a sort of a bit of a hangover, really, of the concept that we would have this zoning. Of course, you would have needed that. You've needed the plan in place to enable that. Whereas it's not quite the same situation now, is it? So whether we will actually see Secretary of State intervention, pretty doubtful, to be honest. I suspect we'll rumble on as we are.
There's a few sort of things that have to be in the plan under the changes, isn't there? So housing need has to be assessed, including affordable housing need, and then the plan needs to meet it, which sort of suggests that maybe not all of the housing policies in the NPPF become NDMP policies. That still have to be dealt with locally. So quite what that means in terms of calculation of housing numbers is not clear on the face of the Act. And then there's this design code.
Yeah, design code as well has got to be included, hasn't it? I mean, I think that's sort of following on from the Building Beautiful Commission or whatever it was called, isn't it? And so it's something that's going to have policy force as well. So again, that's, I mean, local design codes have been pretty common, haven't they? Over, I mean, again, certainly the time I've been doing planning, which is sort of going back to the early 2000s, mid 2000s, but for it to have that statutory force, is a change. Well, what the practical effect of that will be, I don't know.
No. But it's a sort of efforts to speed up delivery is another topic that's interesting, and I think this is very much aimed at housing. I suspect it doesn't say it, and it on the face of it, it applies to everything. But this is about this sort of constant debate about whether the industry is land banking, whether they're sort of bringing forward development slower.
It's like a list of things, Trevor, that sort of like bugbears of local councillors. It's that sort of, like when I used to do the planning committee, when I worked in local government, these were all the sorts of things that local councillors got really cross about. So it's that's the sort of territory we're in here.
Yeah, and it's one of those that completely polarizes, isn't it? Planning authorities convince the house builders are sitting on land banks. The house builders say, well, actually, the reason I'm sitting on a land bank is because I've been negotiating my Section 278 for 3.5 years now, and I've got a pre-commencement condition that requires me to do it. It's that sort of constant tension on which I'm not going to.
And also, I mean, I won't, this will be too much of a tangent, but and also that is their pipeline. So it's like Tesco doesn't just have the stock that it's going to sell that day in its warehouse. It has more, but it doesn't mean that it's food banking. It's it's that's just part of how you run a business, isn't it?
Very true. But there's a few things, isn't there? So it sort of starts with one that on the face of it isn't particularly earth-shattering in itself, which is there's going to be a requirement on planning permissions for the service of a commencement notice. And that's quite often included in the 106, albeit slightly different purposes now anyway. But there will be this obligation to serve a commencement notice, notifying the planning authority of when you're intending to start on site. I think for me that in itself isn't earth-shattering, but it sort of triggers then everything that comes after it in the Act, doesn't it? Although there is this point, I suppose one thing from us as lawyers, it will help us when we're doing due diligence on sites and trying to work out whether works have commenced, and if so, when, because you'll be able to see the commencement
Well,
notice.
selfishly, that's the first thing I thought was of. But I mean, it makes sense, doesn't it? Administratively, actually, I think that will be very helpful for local authorities because, obviously, it just means that there is a record. And there are different contexts that will be important in. So I actually think that's positive. From
those situations that we often find ourselves in, where there are multiple planning permissions, lots of Section 73s, and you're trying to work out
we will know now which has been
which one was implemented. You'll know because there'll be a commencement notice. But it's kind of the other stuff that comes after it that I think is more significant. And one of the things that potentially is quite draconian in some circumstances is the new completion notice provisions. There have always been completion notice provisions, but this in a nutshell, the completion notice it can be served at any point after the grant of planning permission, as far as I can see, which is one of the things that's quite draconian. So the way it works is you serve a completion notice as planning authority. You must give at least 12 months from the date of the notice for the development to be completed. And that period must also be at least 12 months after the commencement notice was served. But that's still quite tight because that's sort of, not much more than a year after commencement that this thing could take effect. And if by the point that the notice, that time period expires, you haven't completed the development, the planning permission becomes invalid. So you then can no longer continue to develop out pursuant to it. That is quite draconian. Now, the good news for everybody completing plannings is that there is a right of appeal. And you can appeal, and you've got 3 grounds of appeal. One is that the time that you've been given is unreasonable. Secondly, that you are building out in a reasonable time frame. And thirdly is a technical one about whether it's been properly served on all relevant parties or not. So if the local authority is giving you, I don't know, 10,000 unit permission, they're giving you 18 months to finish it, that's clearly going to be unreasonable and clearly going to be appealable. But it is potentially quite a powerful tool for a planning authority to encourage quicker build out rates than the market, and therefore the house builders in particular, assuming this is aimed at housing, are going to be comfortable with.
Well, they could kind of force you to do it in 2 years, effectively, from commencement, couldn't they? That's what where that goes. I mean, completion notices have always existed, haven't they? And this just is sort of making it a little bit easier for and broadening the circumstances in which the council could serve one of these. I mean, they're not commonly used, I don't think, are they? I mean, I must suppose I've never come across one. I've come across one revocation notice in my whole career, but I've never come across completion notice being used. And obviously, the consequences would be that anything that had been built would be lawful, but you would lose the benefit of the rest of the permission, as you say. So quite draconian when you combine it with some of the other provisions. So we were talking about, weren't we, the power to decline to determine applications where another planning permission had been built out. I think it's unreasonably slowly is the phrase in the Act, isn't it? So there are some quite good powers there for local planning authorities if they're minded to try and speed up delivery, but at the same time quite draconian, quite a change to how things have gone so far in planning, because the focus is always on implementation, isn't it, and lawful implementation, and then you broadly have as much time as you need to finish the development.
I agree, and I think that power to time to determine is actually really quite significant and potentially quite draconian, as you say. Because I think so it's worth just explaining what that is. I think so. The power to decline to determine, if an applicant for planning permission has an extant planning permission somewhere within the administrative area of planning authorities, it doesn't have to relate to the same site. It could be, if you're a house builder, you might have multiple sites coming forward. But if you've got one with planning permission, you're applying for another. If that existing planning permission hasn't been begun, so it hasn't been commenced, or if the planning authorities have the view that the development is being brought forward unreasonably slowly, then they can decline to determine the planning application that you've put in elsewhere. Now that is draconian in itself, I think. There is a right of appeal because you would still have access to Section 78 appeal in the usual way. But that is quite a power. And what worries me, I think, with it in particular is it sort of seems to me that it's clearly there in order to look to prevent land banking. So if there's a perception that a particular developer is land banking, then you prevent them submitting other applications elsewhere. But actually, you sort of think, if you think back to sort of, go back to just after 2012 and the whole sort of gold rush that was 5-year land supply, there were land promoters who were promoting lots of sites in an authority that didn't have a 5-year land supply. All of those sites were quite often controversial. The reason the planning authority didn't have 5-year land supply is because they didn't like granted planning permissions for housing quite often. So they were resistant to those applications, and it's sort of kind of, once you've won once on appeal, this potentially allows them to keep going, no, I'm not determining that one, no, I'm not determining that one, I'm not determining that one. It doesn't prevent you getting planning permission, but all it's doing is forcing you straight away into an appeal rather than at least going through that application process. And maybe if you know you're going to get a refusal in the first place, maybe that plays in your favour if it means you can get to appeal quicker. But it's one that I think people really need to be aware of, particularly, I think it's aimed at house building. Although, as I say, in principle, it applies across the board, but it's certainly one that I think some authorities might get a little trigger happy with some of these, with exercising that power on controversial applications.
Well, look, there will be a new statutory condition that requires development progress reports on a 12-monthly basis. So, I mean, presumably those two things are or those three, the two powers that we've just previously discussed, are intended to work with that. So, the council is going to be receiving information about what the progress is on the development. So, I mean, I don't think it's clear from the Act actually when that exactly will apply. So whether it will apply from the grant of planning permission, which is what I assume, or from commencement. But I mean, clearly, if you've got the benefit of planning permission, when you are filing those reports with the council, you need to make sure that you give a good explanation as to why the development hasn't progressed, if it hasn't, I suppose, because that presumably will be the sort of information that the council will be basing its judgment on.
And local authorities will need to be careful about costs on appeal. If they're declining to determine applications in an unreasonable manner, then obviously they're vulnerable to costs. So there are some checks, but it's going to be an interesting one to see how it's used, and what local authority expectations are on delivery. And I think we will see appeals where we're arguing about what an unreasonably slow delivery rate is.
There's no doubt about that, is there? Now, I sort of think unreasonably slowly is a new term, isn't it, in planning that we've not sort of come across before. We've got our planning lexicon, haven't we? But this is a new term, I think, that will become quite important.
And actually quite site specific and quite market specific. What's unreasonably slow in a depressed market when there are no sales will be very different to what's unreasonably slow in a strong market, or one site that's more challenging to build out, it will be different again. So I think there's almost not going to be a sort of an emerging body of case law that tells us what unreasonably slow is. It is going to be a planning judgment in each case that makes it quite sort of open to being litigated time and time again on appeal as to whether on this particular site in this particular market a developer is achieving an acceptable, a reasonable rate of delivery. Arguments abound, I'm sure, on that one. So Section 73B is a new one coming in, isn't it? I'm not sure there's much to say about it, but we've talked about Section 73 in a designated outline session last year, so it's probably just worth. We have this new Section 73B, but do you want to sort of talk about it, Ian? I struggle to be excited by it, if I'm honest.
I think the intention is that it's to sort of allow what would currently, I think, be described as sort of minor material amendments, isn't it? So the idea is that you would be able to do something that would have the effect of effectively Section 96A now, but it would be a material change, if you like. And the test for the council is going to be whether the new permission would be, with the change, would be not be substantially different to the original. So it's aimed at things that would be material. So, you can't use Section 96A, but at the same time are not substantially different. So, I was puzzling actually when reading this section as to what sort of situations this might apply in. I mean, one of the things I suppose is, obviously there's a line of case law now that confirms that we can't use Section 73, existing Section 73, to change the description of development. So, that's an obvious sort of change. So we can use this. So even if the change to the description of development is material, meaning that we can't use 96A, then we could potentially use the new power, provided the outcome isn't substantially different to the original permission. Sorry.
I think for me, it's that kind of, okay, so at the moment, Section 73 you can use to amend conditions, fine. Can't use it to amend description development, understand that. 96A you can use to amend both conditions and description of development, provided it's only minor material. So there is a gap, and I suppose that's what this new Section 73B is doing, which allows you to make changes that include description of development, but that are sort of more than 96A would allow. But I'm just not convinced there are very many of them. Maybe I'm wrong. Maybe there are more out there, but time will tell, I suppose.
Yeah, agreed. I mean, I sort of couldn't think of a lot of situations in which this would be important, but that certainly is one, isn't it? If we need to make a change to the description, I mean, there are changes that are sort of on the borderline, aren't there, between material and not material. And at the moment, obviously, whether you can use 96A depends very much on how positive and sort of cooperative the local planning authority wants to be, and the local authority's view of that. So I suppose it removes that consideration, doesn't it? Because something that's on the borderline between material and not material is unlikely to be substantially different to the original permission.
But then if a planning authority thinks that it is more material, they've still got a planning judgment as to whether it's substantially different. And it's sort of, if they're not with you, I'm not sure they're going to be with you on this either.
Yeah, fair point.
It's that for me is, what is the difference? What is the gap? And I suppose only time will tell as we see how local authorities apply it. What is the gap between what you can get by 96A and what you can get that is not substantially different? I'm not. I don't know. Maybe I'm wrong, but I'm not convinced there's a big gap between those two tests.
Well, I got quite excited about it when I first saw it, because I thought, oh yeah, this is going to be brilliant. But then actually, as we've said, once I started thinking about what are the situations in which this might be important, I'm not sure there are a huge amount, but it's another tool in the toolkit, isn't it? Because particularly on large development sites, there is always replanning and the need to go back and tweak things and those sort of things. So any additional tool you've got, I think that can be used in those circumstances is bound to be helpful, isn't it?
Yeah. One of the big ones is, of course, the infrastructure levy. We've had one in 6, we've had still, now we're having another go at it. We're going to have an infrastructure levy. And it's quite fundamental, actually, if this change happens. And I think there's a big if on this. I think this is one of the ones where Labour said they'll repeal it. They get in, isn't it? So let's not worry about it too much just yet. But just sort of in brief, I think, if it comes in, it abolishes SIL in England other than in London, which is presumably to protect mayoral SIL, because the mayor's doesn't seem to be a charging authority for the purposes of new infrastructure levy. Doesn't touch Wales, of course, so Wales still keeps SIL. And it's quite a fundamental difference, isn't it? In short, the devil will be in the detail, but in short, this is intended to be a levy that comes at the end of development and captures effectively part of the uplift in value created by the development. So it's starting to look suspiciously like a development land tax, as would have been back in the heady days of the very first Town and Country Planning Act. And I think that's a big change, isn't it? I think with quite a lot of detail yet to come there, Ian.
Yeah, well, I mean, it is really difficult actually to sort of comment on this, isn't it? Because we just don't have any of the detail. And I think if you look at the community infrastructure levy and then the SIL regulations, I mean, they are ferociously complex. And actually, I think one of the trickiest areas of planning to advise on in a lot of ways. But I mean, I suppose the positive thing, if you look at it from a developer point of view, because it's based on the value of the development, and it will be set, by the local planning authority in a charging schedule. So in principle, it's possible to know before we start the development what percentage of the final gross value will be due to the local planning authority. I think that's positive, isn't it? I mean, at the moment, obviously, it's based on floor space, which is, it's kind of a proxy for value, isn't it? But it isn't exactly the same thing. So, I think it will be positive from a sort of predictability point of view. But I must be honest, I'm a bit wary about it because I just think that, the still regulations have not been that successful. There hasn't been a huge uptake of them for the reason that actually, they're not very flexible. And in some parts of the country, you just can't justify a SIL. I think the intention of this actually is to sort of is to take away the current system of 106 agreements and so on, isn't it? Where there can be quite a long period of time of negotiation around Section 106 contributions and even just the sort of things that will be in 106 agreements. So I think if it works in the way that it's intended to work, which is to cut down that time, so we shouldn't need 106 agreements on most sites. That's positive. If it improves sort of predictability and so on of so that the developer knows what the contributions will be, that is positive. But I don't know, these sort of things. I'm just very wary because we've seen a few different sort of attempts to solve this problem, and it's a sort of it's trying to capture planning gain, basically, isn't it? That's
it's trying to capture planning gain, and it's trying to avoid 106 because 106 is always seen as one of the reasons for delay. And actually, I think that's unfair on 106. The reason for the delay is usually that local planning authorities are under-resourced and they just take far too long to actually negotiate these things. And
well, I do think, though. I mean, I think obviously the sort of the real strong point of Section 106 agreements is that they are so flexible. So there are lots of different ways that we can use to accomplish an objective, and so that is great. The downside, though, I think, is that you do get a position where a lot of local planning authorities will seek things in the 106 that really shouldn't be in there. So going from the sort of trivial level of replicating things that are already in conditions and so on to other sort of more serious things. And I mean, the local planning authority is basically in the position where it can say, well, sign that, or you don't get planning permission. So there's this sort of ratchet thing, isn't there? Where everyone just agrees to it to get planning permission. And so it means that actually a lot of stuff is being loaded into 106 agreements often that shouldn't be there. So, I think anything that's more transparent means that, it's just set at the outset, means we don't have to have that negotiation. I think it's positive.
I agree with that. I agree with that. But I think the issue is, and this is one of the issues with SIL, is originally SIL was going to do away with 106. And then there is quite rightly outcry that you then lose control of what gets delivered as part of the development. Because if you're just paying a slug of cash and then carrying on, you can't secure, if you abolish 106, you can't secure the delivery of the on-site infrastructure in the same way. And affordable housing being just one, but probably the most obvious and the most politically sensitive one. And so I think the devil will be in the detail of how they decide the infrastructure levy interacts with 106. But I am absolutely convinced that they will not do away with 106 for the same reason they didn't with SIL, which comes back to this whole affordable housing delivery. If all you've got to do is to pay a slug of cash at the end and not deliver on-site affordable housing, then you're not providing those mixed communities, you're not delivering affordable housing. And it's interesting that the Act, in terms of infrastructure levy, says that it cannot be brought in a way that reduces the overall provision of affordable housing. And so I think we will still end up with this same difficult relationship that SIL has with 106, where the two things are pulling in different directions, albeit there's potentially some changes to the way that viability works.
I mean, my understanding on in terms of affordable housing is that the local planning authority will still be able to require at least some of the affordable housing to be delivered on site. So I mean, again, it depends on how this is set out in the regulations, doesn't it? But presumably that is intended to sort of deal with any objections about affordable housing. But I mean, this is, I suppose, the point I was making earlier on about 106 agreements. I mean, because they are so flexible, that does allow you to cater to lots of different situations that arise on different sites. And I mean, even things like so one of the problems with SIL is obviously because it's so mechanistic. it doesn't take into account things like viability. So, you know, there might be individual sites where viability is an issue. And actually, you know, if we're doing contributions through a 106 agreement, the council can be flexible there. But of course, if it's a mandatory charge, then it can't be. So, you know, that's a potential problem, I suppose. But, you know, all this is weighing predictability and transparency against, you know, being sort of sensitive to local conditions, isn't it?
Yeah, it is. Enforcement, there's a few changes there as well, isn't there, in the legislation? And this is one of your specialist subjects, Ian, of course. So I'll let you go first on enforcement.
Yeah, I mean, I think there's a few things, isn't there? You know, so one that that really sort of struck me as being important actually is, you know, it's a small bit of the act, but I mean the changes in penalties for breach of condition notices and in relation to Section 215 notices, so, you know, power to require tidying up of land. So they used to be relatively small fines, you know, so sort of level 4 fines, you know, 2,500. Actually, Section 215 could be more substantial than that because there is a daily fine that applies after the first conviction. But they will now be unlimited fines. So, you know, I mean, obviously, you know, that is now uncapped. And I think, you know, particularly in the case of breach of condition notices, I mean, of course, there's no right of appeal against a breach of condition notice. So actually, you know, that could be quite significant, I think. I wonder if we might see more challenges to breach of condition notices, just because now obviously the consequences are more serious. On the other hand, obviously from a local authority point of view, I mean, that now does make them much, you know, much more significant in terms of encouraging compliance and so on. And again, you know, the thing about Section 215 notices is the right of appeal is to the magistrate's court and is just much more of a sort of, you know, onerous process, I suppose, versus the planning inspectorate. So again, now the fact that you are at risk of a large fine potentially, you know, could just encourage more appeals in that way. I think that was one of the main things that sort of stuck out to me. That there are now enforcement warning notices are proposed. So, you know, I think this is probably a positive development. But I mean, this is just sort of putting on a statutory footing, really, that what I think is the sort of normal practice of local councils, which is to initially, you know, as a first step, provided it's something that, you know, has got the prospect of obtaining planning permission, to just write to the relevant person and say, you know, invite an application for retrospective planning permission. So they'll now be able to do that sort of formally through what's called an enforcement warning notice. Whether there was any, were there any other points that you sort of thought were interesting on enforcement?
Well, I think the change in enforcement time periods is at the moment we've got some things. So your building operations and change of use to use as a single dwelling house is 4 years, and then changes of use and breach of conditions 10 years, isn't it? There's a change that everything will be a 10-year period. So certain things that if you got away with it for 4 years, you were all right. Now suddenly is 10. So I think that will.
I mean, it's a pretty big one, isn't it? Yeah.
Yeah. But no, I think that was it for me on enforcement. Heritage, and this one's interesting. So we have in the Listed Building Act, we have the sort of particular statutory test to have special regard to the desirability of preserving and enhancing listed buildings and their settings. I mean, sort of similar but slightly different test for conservation areas. What's happening is effectively that same test, that same protection as is given to listed buildings is being extended now to scheduled ancient monuments, listed parks and gardens, protected wrecks, and World Heritage sites. So on the face of it, that's quite a big thing because it is a special statutory protection that has therefore great weight in the planning system. But I wonder whether actually
you know, there's been a lot of litigation around that duty over the last few years, the interaction of that with the NPPF policies particularly.
And I think that's the interesting thing for me, because on the face of it, it's big, but actually the NPPF policies have always treated those World Heritage Sites and the rest as being designated heritage assets. So the NPPF policies have always treated them in the same way as listed buildings. And we already know from case law that a proper application of the NPPF tests results in the discharge of that enhanced statutory duty. So although I think in legal terms there's a significant difference, in practical terms, I'm not sure it is, because if you're properly applying the NPPF test, you're already doing that duty. So actually, in practice, people have already been meeting that statutory test when they've been dealing with World Heritage Sites and the rest. So I kind of think, although it's a big legal change, I think in practice, as long as you're doing it properly under the NPPF, you're not actually going to have to change the approach, other than to kind of acknowledge that there is the statutory protection for these sites in that way. I don't know whether
I think that must be right, mustn't it? Because as you say, at national policy level, that there's never really been that distinction. So I think it probably seems like a bigger change than it actually will be in practice.
Yeah. Two words, and I guarantee you smile: street votes. I knew it. What's your thought on street votes? What are they, and what's your thoughts on?
So street votes. So this is the idea that small. I mean, I don't think it is actually restricted literally to a street, is it? But it's a sort of a small neighbourhood area can effectively propose its own. I suppose you'd call it a permitted development order. It's the same sort of idea, isn't it? So it can require basically the Secretary of State to make a development order that will apply just to that area. So it can sort of seek planning permission for a particular development in that small, in your local street or sort of locality. With the idea being that you can also require things like Section 106 contributions and set conditions on the development and so on. So the idea, I think it's a sort of micro level extension almost of the idea of neighbourhood plans and neighbourhood development orders, but as I say, just on a very small level. So I anticipate that it will have the same impact on housing supply as neighbourhood plans have, which is to say not much.
Yeah, maybe I'm being too cynical. I don't know, but turkeys don't vote for Christmas, and the idea that people are going to vote to make it easier to bring forward development locally it feels to me an unusual step for people to take.
I mean, I suppose if you were thinking of the sort of situation, I mean, if there were then there may be circumstances in which it would be beneficial for people to have a greater amount of development, perhaps if it allows increases in infrastructure, or I don't know, to pay for some local open space, or something like that. I don't know. I mean, I think that would be the sort of principle, wouldn't it? But I mean, there is not a lot of YIMBYism, as I've heard it referred to, around. Is there? I mean, I suppose again, if that power is there, then perhaps some people will use it. I think the intention with neighbourhood planning, obviously, was to increase. Was to increase the supply of housing, and the thought was that if people have got more control over it, then they'd be more open to it. But I don't think that that's actually been borne out. I'm not aware of any sort of recent studies on it, but I mean, certainly, going back a few years, I think the sort of general consensus was that it had not been very effective. I can't see that this is going to be any different, to be completely honest. But perhaps I'm just being cynical, but I'll be interested to see what your take of it is anyway.
I'm with you on that. Do we just we've got a couple of questions come through, but just before we get to those, just briefly, Ian, do you want to just talk a little bit? We ought to just acknowledge the changes in context of DCOs, and then I know planning data is a topic dear to your heart as well. Is it worth just quickly sharing your thoughts on those?
Yeah, so I think that the significant thing for DCOs is the statutory power to charge now for bodies that carry out public functions. So they will be able to charge for their time when being consulted and taking part in DCO applications and examinations. So I think that is something that's that is really important in the system, because if you look at statutory bodies like National Highways, for example, Natural England, Historic England, quite often actually have to play a reasonably significant part in these large projects and the examination of them, and it would just allow them to recover some of that cost, and hopefully that will be one of the things that helps to speed up the examination process, because it will mean that appropriate resources will be in place for those bodies to give their input, which is really fundamentally important to the way that to those examinations take place. So I think that can only be positive, and I think actually, although it probably it will be an added cost for promoters of DCOs, I think probably on balance it'll be seen as a positive thing, because it means that they can put more resources into the system to allow a better service, which usually I think promoters and developers would be willing to do if it meant that they got that better service. So I think overall positive change. And then you mentioned, I think, planning data. So I think I mean, I'm a bit of a nerd like this, but I do think that this is a bit of a sleeper change that might become gradually seen as more significant over the coming years. Now, I suppose without going into all the detail of it, I mean, effectively what this is trying to do is to promote common data standards across local planning authorities. So the Secretary of State have power to make regulations that require data to be provided in a certain format, that will require certain systems to be used across planning authorities, and for data to be provided in a particular format. So the idea is, I mean, one of the examples that are given in the literature that sort of accompanies the Act is, for example, like conservation areas. Not all councils give information about conservation areas in a standard way or at all. So, with some local planning authorities, it's quite easy to, obtain information on what conservation areas or Article 4 directions, for example, are in force in their area, but in others it's quite difficult. Obviously, if all that information is available in a sort of easily available machine readable format, that means that we can use that in applications, and everyone's got experience of seeing sort of mapping software and so on that can overlay the plan areas, utilities, all that sort of information. So that is effectively the idea. And I think again, this is something that would have been more important if the zoning proposals had remained in the Act, because again, that would have been quite a fundamental change, and it would have been something that would be sort of readily usable within that sort of context of using mapping software and so on. But I expect as things like AI and machine learning and so on become more important over the next few years, I expect that to become a more important provision, I think.
Something that might actually have an impact on the future there. We've got a couple of questions we've just got time for. I think one, just Ian, putting you on the spot, because I'm going to confess now I don't know the answer, but it links to your DCO point. Are there transitional provisions, and effectively, do we know when the various bodies are going to have the power to charge from?
I don't off the top of my head. I must be honest, I thought that came in before Christmas, but we can certainly check, and whoever it is, I'll ping them an email and let them know. I thought that was one of the few things that had come into effect immediately, but I will check and update whoever that is who's asked that question.
The question's been asked anonymously, so whoever the questioner is, if you drop Ian an email and reveal yourself to him, he'll confirm whether that's the case afterwards. And indeed, anybody else that wants to know, I'm sure Ian will happily let you know. But I think you're right. I think it is already in force, but I wouldn't expect it. And then a nice question to end with, really, I suppose. So I will paraphrase, because it's a very long question, but we have clearly given the impression during the course of the last 50 minutes or so, Ian, that a lot of this is perhaps of limited practical effect. And so the question is the Act just a distraction that will fall away after the next election, even if the government remains the same? I think, for me, there are some big things in there. I think that change to the statutory test for decision making, section 38(6), I think that's a big one. Infrastructure levy, if it comes in, which presumably if the government stays the same, they will look to bring it in. That is another one. But there are also things that I think are all, for me, these street votes, I'm just not convinced there's going to be a lot of traction there, and some of the other stuff. That's my answer to the question. I'm not sure what your view is, Ian.
Yeah, I think I agree. I mean, I think well, I mean, some of the things that we haven't talked about are obviously quite significant. So, I mean, I think environmental outcomes reports, for example, is something that actually is pretty fundamental, and something we'll talk about in a future episode. I think I think a lot of the changes sort of assume the current system. So I think a lot of thinking actually in in planning and in infrastructure planning as well has been very much about how to make the sort of existing system more sort of more streamlined and more efficient. And I think some of the proposals will have that effect. But I mean, I think actually really we're at the point where what's needed in both cases is a sort of more fundamental sort of rethink of how how we actually approach the whole question of planning. And it certainly the Act doesn't do that, and of course it did start out as that with the zoning proposals. So I mean, I think it remains to be seen, doesn't it? I mean, it wouldn't surprise me if a lot of these these powers that are on the statute book actually never were commenced. And if you look at the sort of Neighbourhood Planning Act in 2017, actually a lot of that the provisions in that act have still not actually, although they're on the statute book, have not actually been commenced and come into force. So it will be interesting to see what happens. But I think that's a fair summary, Trevor. Yeah, I agree with you completely.
Great. And within time, as always, we try to make sure that we are within our time limit. So, Ian, thank you for joining me. I just thank everybody who's joined the live broadcast, and of course anybody who's watching on our YouTube channel later. We're back next month. We're making full use of the extra day that we have in 2024. So the live broadcast next month just makes it into February on the unusual February the 29th. So we'll be back then, and when we're going to look at, we haven't talked about case law for a while, so we're going to have a session where we just look at and sort of flag some of the more relevant cases of sort of the last 12 months or so that we think people practicing rather than lawyers need to be aware of, and what we need to do to avoid falling into the same traps. So it'll be a bit of a case law analysis coming up on the 29th of February. But until then, thanks again, Ian, and to our viewers, and goodbye.
Thanks all.